Okay, I'll go ahead and call to order this hearing of January 8th, 2026 for Z0088-25, an appeal of director's decision denying a nonconforming use. My name is Joe Turner. I'm the county's hearings officer. I'll start with some brief announcements and a summary of the process that will follow so everyone understands how you can participate in the hearing today. I start by saying I am not a county employee. I am licensed as an attorney and trained as a planner. I serve under contract to the Board of Commissioners. I say that so you know you're getting an independent review of the application before me today. My role as the hearings officer is to conduct public hearings and make decisions about certain land use matters in Clackamas County. In making those decisions, I'm required to apply the county's existing laws. I'm not a policymaker. I don't have the authority to vary from or change the laws. If you think that the laws need to be changed, you can work with Board of Commissioners and Planning Commission to do that. But state law requires that this application be judged based on the laws in effect when the application was filed. As the hearings officer, I'm to provide an unbiased decision maker. I believe I am unbiased with regard to this application. I have not had any pre-hearing contact with any of the parties regarding the substance of the application, and I don't have any interest in the subject property or any of the surrounding properties. But anyone has the right to challenge my impartiality, to argue that I'm biased in one way or another, and you can do that when it's your opportunity to testify. Procedure will follow. I'll start by asking staff to summarize their staff report, copies of which are available on the county's website. Then the applicant will have the opportunity to present their proposal and respond to the staff report. Then if anybody else appears who wants to say anything about this application, in support, in opposition, or with questions or concerns may do so. Once everyone's had an initial opportunity to testify, I'll give staff and the applicant alone the opportunity to respond to the testimony that was offered. If those responses include any new evidence, I'll give everyone a chance to respond to the new evidence. Otherwise, I'll close the public portion of the hearing and announce what I'm going to do without taking additional public testimony. In most cases, I'll issue a written decision within about 2 weeks after the close of the public record. I'll send my decision to the county. The county will send it to parties of record. So anybody who testifies orally or in writing before the close of the record will be sure and receive a copy of my decision when it's issued. Anyone with an interest in this application may offer relevant oral or written testimony. However, testimony should be relevant to the applicable approval criteria, which are set out in the staff report. Also, please don't repeat testimony offered by yourself or earlier witnesses. Repeating your testimony doesn't make your case any stronger. The only issue before me is whether the application does or does not comply with the approval criteria. Sorry, I lost my train of thought there. It is important that all parties make their best case to me. My decisions are final for purposes of the county, but may be appealed to the Land Use Board of Appeals, or LUBA. However, LUBA generally will not allow new testimony and evidence on appeal. They'll decide any appeal based on the record before me. So if you feel it's important that myself or any future decision maker know something about this application, you need to make sure it gets into the record before me. In order to preserve your right to appeal my decision, you or someone expressly representing you must testify orally or in writing before the close of the record. And in order to raise an issue on appeal, someone must have raised that issue before me with enough specificity that people can understand what that issue is. Not much of an issue in this case, but if the applicant wants to object to any conditions of approval on constitutional grounds, they must raise those concerns before me as well. If you feel you need more time to prepare, you can ask me to hold the record open or continue the hearing. If I hold the record open, you'll have the opportunity to submit additional written testimony and evidence before I make a decision. If I continue the hearing, we'll come back and do this again at a later date. But whether or not the hearing is continued or the record is held open for any other purpose, state law requires that I hold the record open for an additional week for the applicant alone to submit a final written argument without any new evidence. If anybody else wants me to continue the hearing or hold the record open for any other purpose or for a longer period, you must make that request before the close of the hearing today. Also, my decision must comply with state law that requires that I issue a final written decision within 150 days after the application was filed. So there's some limit to how long I can continue the hearing or hold the record open. That concludes my introduction. Staff will give us an overview of the Zoom process and then summarize their staff report, or their director's decision, rather.
Can everyone see my screen?
Mm-hmm.
Okay. So yes, today we'll be going over Z0088-25, and I will start by going over the Zoom information. Let me just... Today's hearing is being recorded as required by law. The county will make every effort to post the recording on the county website later today. Panelists for today's hearing, which include the hearings officer, county staff, and the applicant, both have audio and video capability. Audience members' cameras will not be turned on at any time, and the audience members' microphones will be muted unless they wish to testify, in which case they will be called upon to do so by county staff moderator. There is a designated time during the hearing when it will be open for testimony. The hearings officer will make it clear when this is. If you want to provide testimony, you will use the raise hand button feature. For people who have called in to join by phone, you can press *9 to raise your hand. Staff will call upon you when it is your time to provide testimony. You will unmute your microphone and then provide your name and mailing address when you begin. Once you have provided your testimony, you can lower your hand and your microphone will be muted again. If the record is left open at the end of this hearing and you wish to submit additional written testimony, you can email written testimony to mganzer@clackamas.us or mail it to the Clackamas County Planning and Zoning, 150 Beaver Creek Road, Oregon City, Oregon 97045 address. And this information will be the last slide of the hearing as well to take down. My email address is also available on the web page where you found the Zoom link for today's hearing. Testimony must be received by 4 p.m. on the day the record closes. People who testify and provide their mailing address will receive written notice of the hearings officer's decision and a link to access the full written decision. If you do not wish to testify but would like to receive the decision, you must provide your email or standard mailing address by emailing me at the email that will be at the end of the presentation and on this slide here. I'll briefly just give a brief summary of the site. It's located at 46881 Southeast Highway 26 in Sandy. It's zoned TBR and it is approximately 0.92 acres. The application is as follows. The structure was damaged on March 4th, 2024 by a fire. There's a hole in the roof and significant damage to the front lower portion of the structure. Section 120606 requires physical restoration and replacement be lawfully commenced within 1 year of initial damage. The applicant states that the upper rear portion, so that would be the second story in the back, has been continually used as a commercial building space despite the fire and requests verification of the upstairs portion of the building as a commercial office under 120605. The applicant then requests that the restoration of the portions of the NCU lost to fire be allowed as an alteration under 120607. The initial decision is denial. This application became complete on July 8th in 2025, making the decision due on February 24th, 2026, which is 150 days from completeness, accounting for 3 tolls, which amounted to 80 total days. Here you can see a site map provided by the applicant. This shows where the subject area is in this kind of teal color, the upstairs office. The front of the building is a single story, and the primary fire damage was in the front. Briefly going over the site history. The property was zoned RA1 on 12/14/1967. This would have made most commercial uses not allowed. In 1974, the Planning Commission approved an expansion of a restaurant as a non-conforming use. The property was rezoned to transitional timber 20 acres at the end of 1975, and the property was zoned its current zoning designation timber in 1994. In 2005, the restaurant use was verified under Z0797-05, which also permitted an alteration allowing for the conversion of the verified restaurant use to an office use for internet sales. The building was damaged by fire occurring on March 4th, 2024, and the applicant has stated that the upstairs rear portion of the structure has been continually used as a commercial office before and after the fire. I will be going over the criteria that the application was denied on, not all of the relevant criteria, but all of that is included in the staff report, which is Exhibit 1 of this hearing. 120604 deals with discontinuance for nonconforming uses. Nonconforming uses have 24 months, a 24-month discontinuation period. There were 4 primary reasons that staff could not determine that the use had continued and that the use was discontinued for a period exceeding 24 months. Primarily, the 2005 alteration was not lawfully implemented. As I stated earlier, the subject site was approved to convert an existing nonconforming restaurant to a commercial office space for internet sales. This decision included conditions of approval requiring all necessary building permits be obtained. This occupancy would have required a change from A2 assembly occupancy to B business occupancy. And the change in occupancy process would have required that the property owner or applicant obtain electrical, mechanical, plumbing, and structural permits, according to Clackamas County building codes listed in Exhibit 36. There's no evidence in the record that these were ever obtained, which would have rendered the 2005 approval void once the restaurant use ceased. It is unclear the exact year that the restaurant use ceased. The 2005 alteration was to fully alter the site from a restaurant to a commercial space. And based on photos from 2011, it's clear that the downstairs space was converted to an office interior without permits at some point. And so the restaurant use ceased sometime prior to that, which would far exceed the 24-month discontinuance. Additionally, the applicant provided water supply records that demonstrate a consecutive 34-month disruption in water consumption on the site from May or March of 2010 until January of 2013. A lack of water usage is not consistent with commercial use of the structure. Additionally, the applicant failed to demonstrate that the upper level of the building was continually used as an office. There were several businesses referenced as operating on site by the applicant. They provided a timeline showing these, and staff had some concerns with the validity of these uses. The applicant stated that Parkland Property Management used the property from 2012 until 2024. However, the site address was not listed on any of the business documentation provided, which was based in Washington State. Hood Alternative Medicine was registered at the subject address from 2015 to 2020. No evidence was provided regarding the nature of Hood Alternative Medicine's use of the space and if it was consistent with a commercial office use of that upstairs portion. The timeline provided by the applicant also stated that Rockport Crane LLC started operating on the site in 2018. The nature of the business is unknown, and the principal place of business was in Washington State. The previous property owner, Geoffrey Parker, who is associated with Parkland Property Management and Rockport Crane LLC, stated that he used the upstairs portion for business-related storage. There was not evidence provided on the subject businesses showing what their actual use was of the site and how they used the upstairs specifically as a commercial office space. Additionally, to support staff concerns, there is evidence that the upper level was converted to a residence. In 2014, a code enforcement violation was opened due to an alleged remodel of a commercial building without permits. The photos taken in that file, there are photos from 2015 that show the upstairs portion of the structure had at some point been converted to a dwelling. Additionally, in 2019, also in the code enforcement file, there was a Zillow listing which advertised a living space on the subject site. This is corroborated by the fire report, which states that 2 people were living on site at the time of the fire. Ultimately, for this reason and the aforementioned items, it demonstrates that the commercial office use had discontinued for a period exceeding 24 months. And due to the lack of information from the applicant on the commercial office use of the upstairs space, the lack of water usage, and the failure to lawfully implement the 2005 alteration, staff has determined that the use discontinued for a period exceeding 24 months and the application did not meet the criteria under 120604. We'll next be going over verification, there are 2 pathways under 120605A and 120605B. It was unclear from the original application materials if the applicant wanted to be assessed under the 20-year A standard or the 10-year B standard, and the staff decision includes analysis for both. It's now clear that the applicant wished to be assessed under the 10-year standard, so I will be including my analysis for 120605B in the actual presentation. 1 second. So, as discussed earlier, the applicant provided screenshots from the Oregon Business Registry showing that Hood Alternative Medicine was registered at the subject address from 2015 to 2020 as its principal place of business. However, evidence was not provided regarding the nature and extent of their use of the site. It's unknown what business Hood Alternative Medicine was and what they were operating there, if it was a medical clinic, retail, commercial office. And it's also unclear how they specifically used the upstairs as a commercial office space. Parkland Property Management and Rockport Crane LLC, as I stated earlier, both list Joffrey Parker, a previous property owner, as a registered agent with his mailing address in Washington State. None of the documentation for Parkland Property Management referenced the subject address. And similar to issues we had with Hood Alternative Medicine, it's unclear what the nature of the business was. In 2024, the subject addressed as a registered agent listed for Rockport Crane LLC. And Joffrey Parker stated that he used the subject area on site for business-related storage. It's unclear what the business was, but from his statement, it sounded like he was accessing the site maybe multiple times a month and storing files. His stated use of the property stopped in July of 2024, which would have been after the fire. The provided evidence included a gap in any business registration from December 2020 to October 2024, which does not demonstrate continuity within the 10-year period. And the submitted evidence also did not include any information on the nature of the use, explanation for gaps in continuity, or the extent of the use. Staff is not aware of what those businesses were or how they were using the upstairs office as a commercial office space. Ultimately, the submitted material by the applicant did not demonstrate that the upstairs was used as a commercial office for the past 10 years. And so staff could not verify that the upper rear portion met the standards under 120605. Additionally, the applicant provided images showing their use of the upstairs space, attempting to demonstrate that the upstairs office was continually used for commercial use by them. Clackamas County Building Codes requires places with B or business occupancies, such as commercial offices, to have running water and approved sewage disposal. The site has a denied septic evaluation from 2024. Additionally, the walls would need to have fire retardant material, and building codes had concerns with ingress and egress from the upstairs room. This kind of leads us into section 120606, which deals with when a nonconforming use is damaged or destroyed by fire or other natural disaster. So for key details for this, or physical restoration or replacement of the nonconforming use should be lawfully commenced within 1 year of the damage. In that case, this would be March 4th, 2025 would be that 1-year deadline. And the application still has to meet the standards of section 120605 verification. The responding fire department assessed the loss of the structure at 50% in their initial fire report. And on the photo on the right was provided by the applicant, showing the hole in the roof and the damage to the interior of the lower portion of the structure. And the photo on the left is provided by the fire department and shows the upstairs subject portion, showing significant smoke damage. Clackamas County Building Code stated that they couldn't determine if the structure was fit for occupancy without a structural analysis due to the damage to the lower floor. Physical restoration did not commence within 1 year of the occurrence of the fire, because as of on March 4th, 2025, there were no issued land use, septic, plumbing, electrical, or other development permits. One building permit was applied for prior to the March 4th, 2025 deadline. A commercial building permit was applied for on February 13th, 2025, which would have been 19 days prior to that lawful commencement year deadline. And the lawful commencement requires that the permits be issued, not applied for. So ultimately, based on the information that the applicant provided, the staff was able to determine that the use is discontinued for a period exceeding 24 months, and the commercial upstairs use of the office could not be verified. Information suggests that the space has been used as an unpermitted residence, not a commercial space, and there was no lawful commencement or restoration within 1 year. For these reasons, staff could not determine that the application met the standards of Section 1206 of the Zoning and Development Ordinance and denied the application and continues to recommend denial. Up here is my contact information, and that concludes my presentation.
Thank you, Ms. Ganser. I've got a few questions. The Morgan v. Jackson County case cited by the applicant and Coots v. Crook County 22 or Luba 138, 1991 have both held that building and other permits that are not relevant to the non-conforming use status. I think in both cases, use in Morgan, I think it was a junkyard. It may have been also in Coots, I don't remember. Anyway, they were operating in buildings that were not approved, but the use, they upheld that the use as non-conforming, even though the buildings they were operating in were not permitted. So I'm wondering how that affects your conclusion on the upstairs, the current use of the upstairs lacking fire resistance and lacking septic and water, and the possible access issue. Let me go on. There's a little bit more to that. Okay, yeah, that's kind of an observation. I don't know that there's just any question there. My question would be, in the 2005 approval that changed it from restaurant to commercial, the building codes, the decision states, quote, the building code division has indicated that no building, electric, plumbing, or similar changes are needed to convert from restaurant to office use. The condition says if permits are required, you have to obtain them, but it doesn't appear that any permits were required based on that statement. So going back to that initial change of use approval, how that seems to undercut the county's finding that this use was never legally, that the office use was never legally established because they didn't comply with the permits.
Yeah, I still think that the application should be denied on the grounds that there wasn't a water usage for 34 months, which exceeds the 24
Yeah,
months.
another issue. I'll get to that in a bit. But I just wanted to throw that out in case you had any comment, or anybody else from the county or the applicant.
Thank you. I don't know if Lindsay has any comment, but I don't.
And yeah, go ahead, Ms.
Oh, yeah. Lindsay Nesbitt, Planning Manager with Clackamas County. So the condition of approval said if building permits were required, they have to be obtained. And then we spoke with Matt Rozelle, the building official, and he confirmed that to convert from the restaurant to the commercial space for the office, permits would have been required. Okay. And it was adopted as a condition. It was adopted as a condition of approval that they were required to get permits, and that condition wasn't appealed.
Okay. But the building current building official's statement conflicts with the finding in the or the staff decision from 2005 that permits don't appear to be needed. It says no building permits, electrical, plumbing, etc., are needed to convert from restaurant to office use.
Hmm.
So that seems like an affirmative finding at the time.
Mhm.
So you can respond to that later if you want, but that's
Yeah,
how
yeah.
I'm reading that.
Okay. And we have the building official in our audience today, and so I don't know if he would be able to comment
Okay.
on that.
If he wants to, I'm going to go ahead and go through all my
Yeah.
questions, and anybody from the county who wants to respond can.
Mhm.
Um, my next question would be if the downstairs were used for an office before the fire,
Mhm.
could the office use then be moved upstairs after the fire because the downstairs is no longer usable? Assuming you're putting aside those building permit issues, the lack of sheetrock, et cetera. Or would that be a change of use that would require approval, and without such approval, it would expire?
Mhm.
My um with the do you know with the '05 NCU alteration, was it just for the downstairs to be converted to office or was it for the entire structure?
I believe it was primarily for the downstairs, but I would have to go review the actual decision.
Mhm.
Okay.
Um, yeah, I think um, I'd say based on the intensity of that conversion, I guess, yeah, we'd have to know what it was used for before
Hmm.
and what was approved in the '05 to determine whether or not a modification would be required.
Okay. Well, just as a hypothetical, then, if the downstairs were the office, upstairs was storage, and the downstairs is destroyed, could they resume? Could they continue their office use by just moving upstairs while they're trying to fix things, or would that
Mm.
require approval?
Um,
Yeah, there's a
yeah,
lot of
I mean it's
parts
hard,
to.
it's like, okay, would I have to use discretion to make that determination?
Mhm.
And yeah, and like, but if it was used for storage and they wanted to use it temporarily, like, um, yeah, it's all that's why, yeah, I'm
Okay, you
sorry.
don't have to respond right now. If I'm happy to hold the record open for anybody to respond to these issues.
Yeah.
These are just thoughts that are occurring to me as I'm reading this stuff, and I thought I'll throw them out and see what everybody else thinks,
Hmm.
the staff and the applicant. The 20, the code enforcement action, I think it was 28. Was it 2018, code enforcement?
2014.
2014. Uh, Exhibit 37. I think there's a date question there. Um, Let me just a second to get back to the right file. It may just be an error in the uh, exhibit list for that one. Exhibit 37. Oh, yeah. Okay, that doesn't have a date on that one. Um, was there an earlier code enforcement exhibit? There's just photos. There was a letter at some point, but it was okay. Regardless, I don't think it make the I don't think that date makes any difference at this point. But what happened with that action? It was from 2014. Was that file closed? Was it still open?
The status is final in Acela. There is a 2025 reopened case for alleged
Mhm.
commercial remodel of a commercial building without permits. I'm not sure how code enforcement deals with those on their own end, but
Okay. Do we know why the 2014 was closed?
I do not know why. No,
With this, okay. Could we find out what the resolution was?
I can ask them. Yes.
Yes.
I mean, if it was as I understand it, I'm not making any finding, but as I understand it, code enforcement was alleging that it was used for residential at that time. So that what I want to know is, did they close it because they removed the residential, or did they do something else?
Mhm.
On page 10 of your staff report, it refers to Naked Promos Inc. and Click for Promos. I didn't find any. I just looked for those, did a search for those words in the exhibits, and the only thing I came up with was for Click for Promos on the water bills. I didn't see any reference to Naked Promos Inc. in exhibits. It's possible that I just some of these exhibits, when they get scanned, they're not searchable, so it could be somewhere else in there. But I was just wondering where those were referenced, if you know.
The applicant provided those on their timeline, in their initial application materials,
That's right.
saying that
Okay.
they used the site, but no other information was provided to us about what those businesses were.
Okay. I know I'd seen them somewhere. I just, other than your staff report. Um, Sorry, my phone's, I forgot to turn off my ringer. Just, there we go. Uh, The staff report on page 13 refers to a Zillow listing from 2019 to December 24th of 2019. Exhibit 38 is listed as the Zillow report. Where did I do it? I just, there's potential date conflict is what I'm looking for. I'm just trying to pull up the agenda. What did I say? 38? Oh, there we go. The exhibit lists the date of 9/11/25. That may just be when that.
Yeah, the exhibit list, and this may be an error on my parts, the dates are when I obtained the
Okay,
materials.
that's what I thought. So the Zillow listing is from December of 2019.
Yes, yeah,
Okay.
that was when code enforcement dated it.
Okay, great. At this point, that's all the questions I have for staff. Thank you.
Thank you.
Let me get back to my Zoom screen. There we go. Okay. Anything else from county staff at this point? Other county staff? Okay. It's the applicant's opportunity to testify. Mr. McDonald is showing on my screen.
Yes, hi. I'm here with Mr. Paxton.
Okay. Can I get your name and address? I know it's in the file, but we need it on the record as well.
My address is Michael Paxton, 28065 East Water Street. That's Water Street. And that's in Welch's.
And then you need mine as well, is that
Mhm.
correct? Okay. Tyler McDonald, 1550 Northwest NATO Parkway, apartment 1708, Portland, Oregon, 97209.
Okay. It's your opportunity to present your appeal and respond to the staff report.
Thank you. Am I able to share my screen and do
Yeah.
a
Should be. There's,
I don't know, man.
they do this on a lot of different platforms, and I'm not sure. On mine, it's right in the middle. There's a share button.
We don't there we are. Yes.
Okay, good.
Thank you.
Yeah, all these platforms are different. Who knows where the buttons are?
Exactly. Yes. Okay, let's
Okay, we are seeing your screen.
Mhm. Okay, let's put it in.
And while I'm thinking about it, since you're clearly showing a PowerPoint, if you could submit that after the hearing to
course.
Ms. Ganzer, so it'll be part of the record, and it's easier for me to review it.
Of course,
And
yes.
vice versa.
And can we have this their presentation will be uploaded as well, correct?
Yes, absolutely.
Okay, perfect. Okay, good afternoon. I already introduced myself, Tyler McDonald. I've been working with Mike here for the last year and a half. And this is for the appeal of the county's denial for verification of existing non-conforming use under the ordinance 1206. Okay. So I would like to first introduce here the the purpose of the appeal. There's a lot of things that were mentioned within the decision, and I think it's easy to kind of get lost in that. So we wanted to make sure that there are three distinct questions that we will be asking, and most likely you will be using to make your determination. The first one is whether the non-conforming use was established in 2005, but if the non-conforming use was ever discontinued for a period of 24 months or more, and the 1-year restoration rule, was there a permit pulled within a year, or was there continuous use? A summary of the county's decision, like I said, there's quite a bit that was thrown out there. So being able to summarize it here, that they are mentioning, building and occupancy concepts, permit history and alleged permitting gaps, utility, timing of restoration. We want to make sure that we're understanding how those relate back to the questions. So here's where we were able to tie it back to those three questions: lawful establishment, discontinuance, and the 1-year restoration. Going to the next slide here, which is the scope of the hearing. I know it's a little repetitive, but we want to make sure that we're using the correct scope of review when going through the application. And so here, as outlined in one of our exhibits, there are building code enforcement issues at hand that we are working through to try to get more clarity on. And unfortunately, we have not gotten that clarity before this hearing. And within the land use record, there is no final stop use order, land use enforcement determination or anything like that. And I would like to take the opportunity that if there is something in the record that contests that, if Maya or anyone in the county would like to bring that up, because we didn't see anything in our record. Is there an opportunity to ask if they have anything?
You've asked the question, they can respond when it's the county's opportunity to respond.
Understood. Okay. Moving to the next point here. Our concern with using building code compliance is it's a separate set of ordinances that are used. And this has been brought into the land use decision, which we went through and looked at the record, and there was a lot of discrepancies about the way things were being handled. There's no finalization, there's no citation, no hearing. The fees and the actual violation itself was closed out against the previous owner. And there is an indication that this new violation is something that we have inherited. Unfortunately, we still can't get the clarity that we need to understand, is this violation correct or not? And this is not the place to go over that, but I would like to ask if your decision, if you will be weighing any of those building violations, so we know if we need to be entering in anything further.
As I read Morgan and Kuntz, I don't believe that the building code violations are applicable.
Okay.
Especially the initial conversion to office use from 2005. I don't think so, based on what the case that I just referenced, Morgan and Kuntz. But I can be persuaded otherwise by argument. But I will review those cases and make that determination. The code enforcement violations, they're evidence in the record that I will consider. The applicant has the burden of proof to show that the use was continued for the past 10 years under the 10-year standard versus the 20-year standard. So if there is evidence that it was converted to a residential use, even if it's code enforcement, it is evidence. There's photos that show what appears to be residential use in the structure. That shows that something was going on that is not office use. So I will look at that and consider that in my decision. It is evidence in the record.
So if the evidence is not supported, for example, if they are, I don't know how to say this in a polite way, but they're not the subject experts on building per se, but they are on land use.
Mm-hmm.
We are obviously contesting the the evidence in the record, the pictures, the handling, the lack of finalization. So the reason why I asked this question is if there is any weight to this, we want to preserve the right that we can actually address it with our full ability. Right now, we chose to not, flood the record with all the stuff that we have here out of respect to you having to review it all. So if it is something that is weighted, we would like the opportunity to continue addressing why it's not relevant or why it's wrong or not supported. So that's the only reason why I raised that
Sure.
question.
No, I'm happy to hold the record open for anybody. I intend to give the county an opportunity to respond to the questions I've asked and also to give you, the applicant, the opportunity to provide more evidence about these issues. I've got some questions that will summarize my concerns there and my thoughts, I guess. But those code enforcement photos are evidence that something appears to be residential was going on at some point during the past 10 years. The water issue, just that you didn't directly raise that, but it was more beyond the 10 years, but it is evidence that could the gap in the water use. It's evidence that could rebut the presumption established by the 10-year.
Yeah, we intend to, I think, further in this slide deck here, we address some of those points and maybe more questions or stuff come up with that. So
Okay. Yeah, just wanted to throw that out there that you asked that question.
perfect, thank you. Now just being able to have the historical baseline of where we're at here. I know the 2005 was mentioned previously. Diving into that in detail, I mean, we have that in our brief and our exhibits. I think one area that is not defined is that this property has a long-standing approval for mixed usage, residential and commercial. It's a 1987 land use decision. I believe that's Exhibit B1. And this actually allowed back in 1987 for residential use
Trailer, wasn't it?
with the commercial. Pardon?
Wasn't the 87 use approval for a use of a trailer as a separate residence?
It was for the use was allowed on the property. Again,
Right.
defining whether it's a an RV or in the property, I think that's maybe a little too defined than we need to go. I think the point is having residential allowed on the property where there's also non-conforming commercial is a key part that we're highlighting here, that the claim from the county that it's unauthorized on a land use decision that has no expiration or no record of any that just being revoked in any form is where we're using that.
Yeah, but if you can have a commercial use and a residential use on the same property, they're in separate buildings based on that 87 approval, it appears to me. So the issue before me is the use of the building that's there, not whether additional residential use was also approved outside the building isn't really relevant. It's whether what's going on inside the building. So that 87 approval isn't going to allow somebody to move into the structure and live there.
I think we have a different interpretation of that. Not to contest you on the spot here, but based on our review of the cases and the fact that there is no definitive point to any of this, with there being concrete evidence of residential not being authorized, it's just a comment that's thrown out 20 years later. So moving to the next point, the 2005 and the 1987 are both final unappealed land use decisions. This brings us to the localized fire in March of 2024. This, I believe the fire report was provided to you. I think it was. Covered by.
Mr. McDonald, I don't know if you're speaking or not. We're not hearing you. Just wanted.
No, I was,
Okay.
I didn't know if I was waiting for you. I thought you said
No, I
that.
was. Did you have a question there that I
No,
missed?
I was just referring
Okay.
to the localized fire. So carrying on there, localized fire.
Sorry, with
That
this Zoom platform, I never know if somebody's just
I
pausing to
know.
find something or waiting for me or if we've lost
No,
them.
thank you for clarifying there.
No problem.
Localized fire. The extent of the damage was primarily cosmetic. The structure is still sound. The concern with the roof was actually driven by the hole that the fire department cut in the roof to get in and address the fire. And so the primary structure that needs to be addressed is the roof because of, that measure that they had to take to control the fire there. So just being able to address the extent of the fire, that a lot of the stuff can be addressed without permits. The main thing that was needed was obviously the roof to do it the correct way. If we're going to go to these lengths to actually replace the roof, might as well make sure it's fully buttoned up and where it needs to be. That is where the verification of non-conforming use was brought up. It was not something that we were seeking because we didn't know what the property was. We had done our due diligence before getting the property. We had, had many conversations with the county. And at that point, the only path forward was filing this non-conforming to get the roof fixed. This brings us into the first issue, lawful establishment. We are asserting that this has been lawfully established since 2005. We've provided you with the 2005 land use decision, which has the stuff that you spoke to earlier, so I will skip past that part. I would like to point to specific comments made from Maya and Jennifer when we've had conversations with them. There's always been the tone that has been set that we are starting from a established starting point within this conversation. I know a lot of non-conforming properties don't have a starting point like our 2005. So this was a very key moment for us to understand that what we're just needing to prove is that it's been continuously used and that we are just working with the county to get the permits we need. So these two specific quotes are important to us and outlined in the exhibits we provided you. And why we are asserting that this lawful establishment theory fails is, as outlined in the brief, this is something that's already been defined in the 2005 decision by the building department. It was final, unappealed, and the conclusion was no permits were needed. So we're asking that, we're requesting that the determination of the 2005 office use be considered lawfully established for this application.
Okay. Just before I forget on that note, I want to throw this out so you and the county both know where I'm thinking.
Yep.
In Coons v. Crook County, which I cited earlier, the LUBA held that consistent with Morgan, that building code and licensing compliance isn't a land use regulation, but where the code or a decision implements building code or licensing, then it is. So as a hypothetical, let's put it that way, if the 2005 decision had said you must obtain a change of use permit from restaurant to commercial, then the fact that building permit would come in that way. But as I noted, given the language in the decision and the phrasing of the condition, I don't believe it does. But that is that's the standard as I read it, is if building code generally doesn't apply unless it's expressly incorporated either through the code or through a decision.
Right. I would like to just follow up briefly on that point that it's been 20 years and we don't see anything in the record that indicates the necessity for this change through our due diligence and conversations. It wasn't until late into this application process that it came up. So preserving that there. So moving to the next point, the discontinuance here. I won't go into great lengths on this. I believe this is just determining, has there ever been a 24-month period where the property was not in continuous use. And I think being able to define here that it has to be a complete stop of usage for 24 months consecutively. There isn't a, we're going to tally 3 months here, 7 months later. I think it's important to define here that it's a complete 24 months of no activity. And I think that's important for our next couple slides. We don't believe that they met that standard.
Well, again, it's not the applicant, the county's standard that the county doesn't have the burden of proof, the applicant does. So you have to show that it wasn't discontinued. You have to prove a negative, in effect. It wasn't discontinued for 24 months.
Of course, the way that it's being addressed is we've shown the 10 years. They have shown that they
you have to show the 10 years. You have the burden of proof. If you get to that point, then there's a rebuttable presumption and the burden shifts.
I think the better phrasing would have been the contesting. I think the continuous contesting here, that the burden does shift to them after 10 years. And at that point, if they're now providing something to us that they believe is not proper, I think that's where we were going with that. So we did go over the 10-year and when Maya presented there, just reiterating here that the decision relies on the inference from the utilities, that the utility itself is not outlined in this ordinance. It doesn't say that you are mandated to have running water or to have, within reason, that would be a separate set of procedures outside of
whether it's required or not. It is evidence that nothing was happening. Arguably, it's evidence that nothing was happening here because commercial use, office use is likely to require some kind of water. Right now, you're not, but if it was connected to water, which it was according to the documents, the billing, but there wasn't any. Nobody was using it, so.
Well, and just if we only had the utility data, I would say that's maybe a valid point. It still doesn't point to the fact that, there's a well on the property, maybe there was some other way that was being used. Obviously we can't speculate on what that was, but right now I think it's important to define what we can prove, which is going into this timeline.
Okay.
And now that I'm looking at it, that is quite, I don't know if I can zoom in here.
And just to confirm, this is, it looks like it's already got an exhibit number. Yeah, that's the one that's already in the record. That's what I want.
Correct. Yes.
Relatively small here, but I've seen it and I'm familiar with it.
Yes. Okay. Sorry, it's a little overwhelming.
No, that's okay. You're fine.
So the period that they're referring to is the 2010 to the 2013 timeframe. And I think it's important.
This is the water discontinuance period.
Correct.
Yeah.
Correct. Yes.
2010 to what was 2013?
Yes, I believe Maya said it was March.
I've got the dates in my notes. That's okay.
Okay. I think it's important to highlight these blue boxes here that there was 2 sales within that period of time. And the ordinance is very clear and case law supports it that it has to be no activity for it to be considered, interrupted and then discontinuance, that's how that progresses. Within here, low activity does not equal no activity. And we're not claiming that there was necessarily low activity. We're just saying that the indication from the utility data showing no usage, while that might be concerning on its own, I think it's important to consider that the account was active. There were metered services running there. We had 2 sales, within arm's length of each other. And overall, we can see that commercial taxes were paid, that LLCs were registered that do have the address tied to it. Snapshots of all these things. Now I'm going to zoom out here and go to the next slide, which is the Zillow listing that Maya mentioned before. And I think it's important to clarify and contest the date that she's using right now. She's claiming that this is from 2019. From our records of what we pulled, this is actually from 2011. We've used many sources like the Wayback Machine. We've gone through different sources to try to confirm what we're looking at. These are pictures from 2011. So regardless of Zillow date, we are looking at pictures during that time frame that's being contested right now. And it's really important to see that there is electricity on, there's lights on. Now, PGE unfortunately cannot release those bills to us as we are not the last owner. Otherwise, we'd be providing that to you. But we can see here that the office is structured in a way, with electricity, desks in there. And this is, a snapshot in time here showing that someone was in the building with lights on. So I think this is an important area to clarify and point to in terms of that discontinuance claim.
Yeah, and I know that was one of my questions for the applicant that I have on my list, is these photos show a 2011, on the photos, a 2011 date. Do you know, was that from the Zillow listing? Is that how they appeared in the Zillow listing?
Yeah, that's how they appear in the Zillow listing, correct.
Okay.
Exactly where
Yeah.
we got it.
That seems evident that these photos are from 2011. I'm not making
Yes.
that finding, but that's what it appears to me.
Yes. So important part to highlight of that timeline here is that someone was in the building. There was like electricity, just to summarize there. So moving to the next point, because we can show that there were sales records, commercial taxes, lights on in the building, people, someone was in there at that one point taking the picture. We conclude on our part that that does not equal 24-month gap, regardless of what the water consumption shows. Now, whether that is a separate topic that needs to be brought up with, the building department, I think that time has come and gone for that date period. But I don't think we don't believe that this is applicable for the land use matter based on the case law and the evidence we provided. So we are requesting that this not be considered for the discontinuance under 120604. The final point or final question that we outlined in the beginning here is the fire and 1-year restoration. This ordinance is the ZDO 120606. And there's 2 pathways to achieving this after a property is damaged or destroyed. Again, we'd like to clarify that the extent of the damage is it is not destroyed. The structure is safe. I just want to outline that there. And that the office use was used before and after the fire. So the fact that it was being used preserves that right. It was something that was outlined by Maya, Lindsay, Jennifer. These are all standard concepts that are used for partial verification moving forward on that. That was outlined to us on many occasions. So I think it's important to highlight the 4 attempts for permits. I know Maya highlighted the 2 building permits, but there were also 2 septic permits that were put in back in, that would have been July and March of 2024. So a little after the fire, then there was one. July was the second one. So there were 4 attempts.
2024, right?
Yes, correct.
Okay.
So there were 4 attempts to get permits. And I think there's a level of yes.
There's how do you get 4? There's a septic twice you just mentioned, and then the building. What's the 4th? So July and March of 2024 were both septic permits. There was a building permit February, I believe, of 25. What was the 4th permit?
There was 2 building and 2 septic. The building. Okay. The second building was in March, but that one was at the advice of the building department. They were wanting us to put in an application for residential just to get the roof opened up. But the other 3 are within the time frame. We're working closely with the county to just make sure everything's buttoned up and we can get these approved. But we would like to note here that it was not for the sake of throwing permits in to preserve any right. We knew that we were using the building. We were aware of the law. We knew that what we were doing is, we want to make sure the permits are put in correct and that the work that's being done is going to benefit the building and overall use going forward. So, the comment of it being put in last minute, I think is irrelevant since we were using the property for preservation. So,
when were the 2 building permits submitted? Just so I have that.
One was in February, early February, I believe. I think
25.
Correct. And then there's a second one that flows into March of 2025.
Okay.
There was also attempts for a demo permit, which was we were steered clear of that. That could have been issued very easily, which would have, we were steered clear to go the different route of, the residential roof and trying to get this all squared away. So there was many attempts for emergency repairs and all this stuff, and none of them were able to be put through for some reason. So the only reason why I bring up these efforts is the fact that there's two parties to getting a permit. There's the applicant that's trying to get it, and there's the county that issues it. And right now we feel like we are stuck in a kind of a cycle where you can't get a permit until you do your non-conforming, but then you do your non-conforming, and we're going to say because you don't have permits, it's not approved. So we're being sent every which way from building to planning and then planning back to building. The efforts were there to get these permits here, but I think it's irrelevant for the purposes of 1206 since we were continuing to use the property. So, with that being said, the conclusion we're requesting here, since the non-conforming was requesting the entire property to be non-conforming, not just partial, that was entered at a later point from Maya as she got that from Lindsay and higher planning staff. But at the minimum here, I think we're not asking rules to be changed or going outside the box to do anything. At the minimum, we would request that partial verification of the rear property is approved, allowing the permits to move forward on the roof there, and once that's fixed, doing an alteration. So I think that is reiterated on this slide here for reversing the denial and then overall confirming non-conforming use to allow that to move forward. And that is all we have.
Okay. I'm not sure this first one's even a question. It's more of an observation that I forgot to bring up. Oops. With the county. All right. I hit a wrong button and I moved my page. Let me find it again. Under 120606B, big enough so I can actually read it. Apologies. It says lawfully commenced means lawful resumption of the non-conforming use or issuance of land use permits, building, etc., or other permits. So an argument can be made that, assuming a lot of things, that the resumption of the office use upstairs could potentially, if those other background issues are addressed, resolved, that would be sufficient to maintain continuance of the non-conforming use within the 1 year. That's more of an observation for the county. I think it's consistent with your argument, but I just wanted to throw that out there because I missed it before. My questions for the applicant: when did Mr. Parker, Jeffrey Parker, acquire the property? I didn't see that in the record. It might be in your timeline, but I didn't catch it.
That was in 2012. So it was sold from Juan Cortez, and in 2010 it was sold to Jeffrey Parker in December of 2012.
Okay.
No.
Do we know when Mr. Parker began using it for commercial office use? His letter says I used it through July 25, I think, but it doesn't say when he started.
He used it throughout that consecutively through the whole period. The letter that was written was at the request on the incomplete notice was defining very specifically the events of the fire and how that developed, a little bit before it into afterwards to make sure that, there wasn't any concerns there. But the consistent use from Parker in different forms has been documented and supported.
Okay. I think some of my other questions have been resolved with the testimony and things presented. But yeah, I had to look at the staff report real quick, mostly about the photos. So the Zillow photos, what I was going to ask is if those were from 2011 or 2019, and you addressed that. And then there's the same photos that are used in the staff report at page 9, and it clearly is. So my next question would be, Hood Alternative Healthcare, do we know what they did at the site? Staff did raised that them as well. Was it an office use? Was it a clinic? Was it retail sales? They're registered as a, I think, place of business. It's in this. The site is clearly in their corporate documentation that you've submitted, but that's all there is. We don't know what they did. What was the scope and extent of their use?
It's we would need to go back and look at that. As far as we know, it was office use. But before that is confirmed, we can obviously go back and look at what we have. I think I think that's as far as I'll go. We can look and see what other stuff we have here. We have quite a bit of information that we've been willing to provide to the county, including how we're using it, to the extent that it has not been requested. We've had very clear guidelines. We provided what they've asked for, so we don't oversend things. And I think obviously there's over 600 pages in the exhibit. So if there's more stuff requested, by all means, we're willing to work with any party to get what we can to support where we're at.
Okay. The fire report says there was no electrical power to the site prior to the fire. Your electrical records, you argued that there was continuous power. I didn't look at that specifically, whether there was some interruption right before the fire or not. But that's a question I had. If you can resolve that during the open record, great.
It's limited on what we can get, considering
people. Oh, right. You can't get the
they won't
PG record.
release anything.
Yeah, I remember that statement. So
yeah, we tried getting what we could, but as far as we know, it's been continuous.
Okay. As I understand it, I'm trying to keep my name straight, Mr. Parker owned it right before Mr. Paxton, correct?
Correct.
And so is there any evidence that he used the upstairs for an office other than storage of records?
Well, I'm not sure if you've read the entire statement there. I think
I've read everything in detail, but like you said, it's an extensive record.
So I would like to clarify there that that statement was written and notarized for the context of what they were asking in terms of how it was used post-fire. And I think it needs, I think the hard part to really size that down to just be a storage when from the conversations we've had with him, he works in property management, or might be mistaking what he works in, but that's where his records are. That's where he was, there regularly. I think really diving into it and having a detailed conversation about storage versus, office use, we really need to define those in detail to really determine if having files there and going there regularly to pull them for business purposes, if that is considered storage or if that's continued active uses post fire, obviously with what was going on there. So I think that's kind of the out of context way that it's being presented. That again, if further explanation or support is needed to emphasize the full extent, then that can be done.
Okay. All right. Excuse me. What was I going to ask next? Let me hit a cough drop real quick. Sorry. Oh, I know what I was going to ask. More of an observation. If I'm operating a business from an office, that's my office space. I also have a storage unit, one of these multi-story public storage things where I keep my files. That public storage facility isn't part of my office use. My office uses. So that's what I'm requesting clarification on.
But this is, again, if the filing cabinet is in your office where you do work.
Right. Is he in his office doing work, or is his office elsewhere?
Right. So I think that's the distinction that we were, again, I think a lot of this could have been resolved with further clarification questions on that front.
Okay.
You know,
Yeah,
on
so
this
that's
side.
why what I'm throwing out there. If you
Of
can
course.
answer it during the open record, great. Is there evidence that Mr. Parker used the upstairs for the office before the fire? Because Exhibit 19, the fire report, says the tenants, the people who were living there, we'll call them tenants, were served with an eviction notice by Mr. Parker. And I think their last day was the day of the fire. So if they were living there and how was he using it, that upstairs for office use or storage or anything else? It may have been illegal, I don't know, but that's something I'd like to, if you can clarify.
Sure. As far as we know that it was completely closed off from what may or may not have been happening, I don't think there's any definition that we can provide to that. In terms of the alleged residential use, I know there's mentions of it in the stuff there. We don't have the full definitions of that. What we can say and what we understood from the conversation is that it was completely separated from the property. There's like different doors. I mean, the structure, the way it's set up, there was different
Sure.
access up to where that was being used. We could get more information as needed. Like I said, I think that's if that is something that it's hinging on, we can get more clarification on how exactly it was used from Parker up to current.
Okay.
When he's
You're right. I understand that the upstairs is effectively a separate unit or area, but if you're going to, one way to interpret this is the commercial use is the building, upstairs and downstairs. It's allowed in the building, even though its commercial use was limited to the ground floor where the restaurant was, and clearly the photos show it was used and converted to an office at some point. The upstairs is separate and used as potentially as a residence, potentially as storage, a variety of things it could have been used for. So those are the questions I'm thinking through. And I will have to resolve those. But if you have some argument during the open record that address that.
We mentioned that in one of our exhibits. I think it's in either the 2B, 2C, or 2E. Within one of those submissions, I think we outline the extent of usage and how things developed during that time frame. But if there is more clarity that we can bring to that, obviously we will do that.
Okay. Yeah, it's just the fact that those tenants were there on the day of the fire, clearly, that raises that issue. And again, I'm not ruling on any of these things. I'm throwing out questions that I have that I'll have to resolve, and I want to get everybody a chance to address those, so it makes my life easier.
Sure.
Then I don't have an exhibit number or a date even, but there's somewhere in the record, there's photos from the enforcement files that appear to show a residential kitchen, which appears to be on the ground floor just because the ceiling in the kitchen is flat and it looks like the upstairs is ceiling, basically an attic space. And then there's the other photo that was in the enforcement record was a living area with a TV and a couch or something. So that is.
Yeah, we're contesting those. That's part of the building concept that we're contesting here. That's being used without any clarity or support on what the violation is, where that ended up. I know you're looking at pictures, but I think it's important to define here that there's not a definitive explanation on, we don't know that there was ever a proper inspection or consent to go in. We don't need to dive into all this right now. I think the point
Okay,
is.
but it is evidence that's in the record that undercuts the commercial use of this building.
But if it's not verifiable evidence, then that's our argument. It shouldn't be used. So
right.
Again, not to dive into the building concept too much, but I think it's important that if it can't be verified or supported, we're unclear on how that can be used as evidence.
Okay.
or shared.
It's evidence it's something a reasonable person would rely on in the conduct of their ordinary affairs. I think that's the definition of substantial evidence. So it's whether it was legally obtained, I have to assume it was, or not even, it is evidence that there appears to be some kind of a residential use in there at some point. That conflicts with the argument that it was in continuous commercial use. So
I think that pushes it to the stance, though, that how do we prove that two snapshots in time of two points in a property
yeah, it is a difficult burden of
how,
proof,
how do we
but it is the
say that
applicant's
that's
burden of
descriptive?
proof.
Right, and I think from what we've shown with our timeline and everything, I think getting detailed in that, if it needs to be, you know, we will address that. But I think the concern is without the full context of what was taken or not taken, if it's, you know, factual or if it was done correctly, I think that's all relevant to the fact of how it's being used in a separate legal matter. And again, that's not our decision to make, but it's just something that we are contesting at this point.
Okay. Thank you, Mr. McDonald. Anything else you want to add before I go back to the county or open it to public? But I don't think there is anybody, but I'll do that anyway, just in case.
Yeah, I think just closing of sorts and pointing to what we believe was our next steps prior to the denial. A non-conforming can only be lost once in our interpretation here, and it seems like we are looking at multiple potential situations where non-conforming may have been lost. And I think being able to define and get the clarity we need from the county, it's really hard to just throw all these arguments out and say, we think it was lost at one of these points. When there's a denial on the record, I think it's really important to understand that there needs to be a pinpoint accurate, we believe it was lost at this point. And what we're reading in the decision and from the presentation today continues to reflect this idea that there can be multiple areas of it being lost. And the purpose of what I'm bringing up is if it's a 1-year restoration that they're saying is where it was lost, it invalidates all the previous arguments because you can't lose it twice. Vice versa, if we're arguing that it's the alleged residential use in 2014, that would invalidate the argument of the 1-year restoration. So I think this comes down to the idea that you can't
More alternative arguments rather than multiple losses. You know, if it was
close.
lost here, there was nothing to preserve. But if that gets overruled on appeal, and they're arguing that it was also lost here, and same thing, or lost here. So we have to address all of those.
Of
It was
course,
lost once. It only has to be lost once through one of those processes. But the issue is whether it was lost.
Understood.
So,
I think I'm calling out the subjective versus objective portions of what's
right.
being defined. Beliefs on when they could have been lost are not pinpoint. This is where it was lost, and we're denying you based on it. So that's the indication what we wanted to do. And on top of that, pointing you to the Exhibit C4, there was a list of questions that we were attempting in many different forms to try to get the clarity from the county. And you know, the denial had come through. It's just kind of the next steps, next thoughts of where we were going before the denial to try to get that clarity that we needed and potentially not have to have this hearing at all. And so wanted to point you towards that exhibit as well, explicitly to show the questions that in our mind are still outstanding to be able to move forward on denial.
Okay. Thank you, Mr. McDonald.
Yep.
For the record, is there anybody else out there who wants to say anything about this application? It looks like the only attendee is a county person, so none. Anything further from any county staff?
For the Zillow photos, I would agree that the ones dated 2011 are from 2011. The 2019 date came from the date on the code enforcement file. So I don't work for code enforcement, so unclear if that is the date that they obtained that screenshot or if that's the date that they saw the listing and screenshotted it, and the 2019 listing was using photos from 2011.
Yeah, given the description, it appears to be older photos, but yeah, I don't know that when the code enforcement, yeah, I understand, but thank you. And if you would get more clarification from code enforcement about what happened, why it was closed, that'd be
Yes.
great.
Um,
Mhm.
Matt
Okay.
Rosell, the building official, he can offer a couple of comments if you're
Sure.
interested.
Absolutely.
Okay.
Mr. Roselle, you appear to be.
I think Darcy's bringing him
Does
over.
Matt want to be moved into the meeting?
Yes,
Dallas.
please. I told him that he's
Okay.
coming.
Okay,
He's
great.
been messaged. He's been
I just don't want to put him on the spot.
Yeah, no, he knew. Hi, Matt.
Hi there. Um, yeah, I'll just add from,
Can I
and I
get your
think
name and title, Mr.
oh,
Roselle?
sorry, Matt Rosell. I'm the building codes administrator for Clackamas County. From a building code perspective, if a structure, whether it's residential or commercial, does not have water, that is an unoccupiable structure. So if you had a loss of water for 30 months or whatever that date was, then you did not have a legally occupied building for that time period. And then also, I had not seen the 2011 photos, but if you are doing a change of occupancy from a restaurant to an office, that would require a change of occupancy. So I'm not sure where that note came from that said permits weren't required. That confuses me. But
That's from the 2005 decision by the county.
right, and I know it's there, so I'm not arguing
Yeah.
that, but that's confusing to me because
Yeah.
even in the UBC back then, that would require a change of use. But seeing those 2011 photos also, the amount of work that was done would at least require electrical, and it looked like they did upgrades to the ADA bathroom. Those would require permits for those, for all that work that was done.
Okay, let me finish my note, then I have a thought. The changes to the ADA bathroom, that would be a plumbing permit, I assume.
And a building permit.
Okay.
Yeah.
Okay. Finishing my note. I'm sure somebody would have submitted if we had it, but I'm wondering if there's any photos of the restaurant use beforehand. But just that was my thought. I'm sure I assume they're not out there, or if somebody can dig them up, great. Love to see those, because that would show what was changed and how it was affected.
Right. I've not seen those if they're out there.
Yeah, I didn't think you would have. Okay. Anything else from any other county staff? I'll ask the applicant as well, but how long would the county want the open record?
Do we get an opportunity to contest what was just said?
Absolutely. Yeah,
Okay.
you're next. You get final word.
Oh, gotcha. Okay.
And I'm asking the county how long they want. I'll ask you how long you want as well. I'll go with the longer, if you will.
Maya, I'm going on vacation tomorrow.
Okay.
So, but Maya can work with Jennifer. So
Yeah, I'm content to keep the record open for
just
what
the
the
1 week,
applicant
1 week,
requests,
1
the
week.
1 week, the
1 week?
standard.
Okay.
Yeah.
Okay. Okay. Mr. McDonald.
Okay. So just contesting what Matt Rosell just said. The 34-month gap, there would need to be a definition that there wasn't accessible water on the property. What we're seeing right now is there's still metered services, the account is still active. There would need to be some conclusive documentation that water could not have been accessed on the property for that, in my eyes, to not be a proper thing. And again, that's a Title IX.
I see what you're saying. Yeah.
Yes.
In order, under the building
concept,
it would have to be not accessible. The fact that it wasn't accessible is the county argues is evidence that it wasn't used. But I gotcha.
Right. I'm just trying to clarify here that we're using the 34 months. He was mentioning that from the code standpoint. I think there's a question of access, was this deliberate to not use? We can see there's still metered services, account was still active. So if you have any weight in that comment there, we want to make sure that it's preserved, that those are very relevant points to the fact that it would need more definition to be conclusive that water is not there. And then the kind of arching kind of thing there is that these are all building concepts. They all
Right.
fall under, the chapter 9, code enforcement. And the issue with that right now is, to this date, we still have no definition on the clarity we've been asking from the county. We know what we're looking for. So for this to hold weight, and for Matt, to come in here and explain that point of view with, this has been known that the property's been used and all these concepts, yet there's no enforcement, there's no proper, record keeping. And so if this is to hold any weight, we would like the opportunity to go forward with a violation hearing to make sure that whatever's in the record is actually clear if there's going to be any weight to it used in the land use hearing, because it is being used. And if the evidence is wrong and it was mishandled and we get a result from a violation hearing standpoint, that would impact us directly in this decision alone. So that's why we asked for it to be excluded. We asked building if they could do something about that. We asked planning. And the result was, our hands are tied. So we asked the same thing from you. If there's any way that this can be excluded or extended out until we get that clarification, if there's any way.
I'm happy to hold the record open for a period of time for you to provide additional evidence. I'm positive the county wouldn't proceed with an enforcement proceeding because there's no residential use going on. It's ended. So I understand your desire for clarification, but there is photos of this building with residential use, and there's also the fire report that it wasn't used for residential the night of the fire. So
we're contesting that because right now the violation itself has evolved into 4 or 5 different stories. 1 minute it's lumber being brought in and there's a complaint that lumber is being brought in and improper work is being done there. The next minute,
that I'm not considering. It's the photos that I'm considering.
But they're tied to the original violation. And so anything in that original violation, if that becomes void, that would mean everything in the record becomes void.
I don't agree.
Well, that's what
it's evidence that there was some kind of a residential use going on in the building, and you have the burden of proof to dispute that in some way.
And we believe that we have in our writing. So again, if it's holding the weight, we need to get that clarification from building. So we would ask you again, are you holding any weight in these violations or in the pictures or anything related to those files or building concepts at all? Because we have to know if we need to hold it open and ask for a continuance if you are weighing those situations.
Okay. I don't know at this point. It's all in the record. I'm going to have to work my way through this decision and consider that. The 2005 decision, it appears to me to be pretty clear that it says a finding, buildings, permits, plumbing, etc., were not required. So I don't see how I could find that it was, and therefore the conversion to office never occurred. The issue, I think the primary concern is whether it was converted to an office and then that office use was continuous without interruption of 2 years during the preceding 10 years or preceding 20 years if there's evidence to counteract the presumption of 10 years continuous. So that's what I'm considering. The current building violations, to the extent they're, I don't think those are relevant either.
If you're using the pictures, that's what we're asking. Because if you're using those pictures and the residential concepts, then we need a pinpoint accurate answer that building unfortunately is not providing. And if that means we need to go to a hearing or we need to figure out.
A pinpoint accurate answer. The photos are taken on this date. There was evidence that it occurred on that date. That was there on that date.
We can't be conclusive on that. I know you're saying that's conclusive. The argument is if the record was mishandled from the very beginning and it evolved and we go to a violation hearing where they void out the enforcement or whatever the equivalent is that they do. Right now, that means that there's never been a citation, there's never been a red tag, there's no finalization on
But if
this.
some neighbor showed up with these same photos, it wouldn't be any different. These photos are photos.
I think it
However,
would-
they got into their, they're there. They exist.
I think it would
Taken on a
actually
specific
dive
date.
into how can we need to prove that what's being shown is accurate. And I think that's what we're contesting right now. And you're looking at it, and I understand that, but if you're using those pictures, they're coming from the code enforcement file. And so if you are using those for weight, we would need to get the clarification, and we would need to make a determination on how long we need the record open and if we need a continuance. But we can't answer that until we know if that's going to hold weight or not.
Okay. If we can continue or we can hold the record open for a longer period, either one, we don't necessarily have to come back to a hearing, but we can. If that's an option, if that's the way you'd prefer to proceed, I'll consider it. There is the 150-day clock can't go over roughly a year. I don't remember what the exact deadline is. So if I hold the record open longer, I'm going to ask you to toll the clock for that period up to the maximum amount. I can't go beyond the maximum amount, period.
Right. I would also like to call out here that there was a comment about the tolling period. Planning held this record majority of the time, and we do not want to hold this open if it's unnecessary, because the building's in the elements right now.
Yeah,
And
I understand. So I'm happy to do this as soon as possible, but I'm giving you the opportunity to submit additional evidence. So how long would you like to submit the additional evidence?
I think that depends on the weight of the records that are being entered. If we need to go through a building and get this clarification, then we're going to need more time. If you're not using that as weight, then
I am going to consider those photos. I'm going to.
You're going to. Okay, so then we're going to need additional time then.
How much time does the county need?
It's hard to answer on the time frame here because we've been working with building to get this clarification. Is there a way to answer after this hearing?
Yeah, that's what I was going to suggest, is if I give you a week to respond and say, we want the record open until this date and toll the clock for that period.
I mean, if Matt is still available here, maybe he can comment to us being able to work back with him. We've been working with him. I think there's still an unanswered email that we sent him if he wants to loop back with us on that.
Like, if he's able to meet with you within the next week, is that what you mean?
Now or whenever he's available. I mean, just being able to comment on the record that we're moving forward on that. I don't know if he's still here or not. So
he is still here. I'm not going to put him on the spot and make him.
Sure, understood.
I resolve that question, but if you want to meet with him, we can check his availability, I think is the best way to proceed. Mr. Roselle, can you comment on? Would you be available to meet with the applicant within the next week to discuss this?
Yeah, I one point of clarification. Are you asking for a code enforcement hearing to go through the code enforcement case, or are you just asking to discuss?
I don't think the county was going to proceed with the code enforcement case because any violation has ceased with the fire. So I don't think that's an option for the applicant or the county.
Well, I guess he's contesting the way in which the code enforcement case was handled, which we put all of our evidence into the SOLA. And, we've given him those records that there was, a code enforcement case opened in 2014 that was never resolved. We sent letters, we sent violation letters, and it was never resolved from the property owner. So we provided them with all of that. I guess he's wanting, these clear, pinpointed answers that we don't have. So it's difficult to get him some of the answer some of the questions he's asking because we don't have that historic, other than what's in the file, we don't know. So
you don't know why the 2014 case was closed eventually.
Right.
Okay.
Or why it was started. I mean, I would ask that question now. I mean, that's the point of what we're asking. Is this
generally it's a complaint-driven process?
it
Go- I'm
was
sorry.
complaint driven, and it was opened because there was, we were, somebody let the county know that there was unpermitted work happening in the building, which, I believe it was Scott East mentioned, and I don't remember exactly what the wording was, but there was work being performed in the building without permits, and that permits were required. So
Which would be a building issue, and it's developed over time to become allegedly a usage issue. And there's been no finalization, no citation, no hearing. It was closed out. And the question that we're asking, is it an inherited violation of the old one, or is it a new violation on its new merits? So
Whether it's a violation or not, the issue is, was it used for residential instead of office for some period during the 10-year period or the 20-year period? There's
Right,
That's
that's
the issue.
relevant to the conversation we're having here in this hearing. But if we're using evidence that ends up being wrong, it's the concern I have. So again, I don't want to.
If the evidence is wrong, you can show me that it's wrong, but
Sure.
it's photos of the interior of the building. So that however they were acquired, I don't see how that's relevant. I'll let you make that argument.
Of course, yeah.
So
Yeah.
what I'm going to do
And-
is give you a week to discuss this with county, however you're and you're amongst yourselves. Let me know how you want to proceed. Options would be, at this point, I'm going to hold it over for a week for the county to submit new evidence and testimony. I would hold it open for a second week for anybody to respond to that new evidence and testimony, and you could submit new evidence and testimony during that first week as well. I'd hold it open for a third week for your final argument, which you could waive. That's the minimum. If you want more, you have to let me know within a week and toll the clock for that period.
So if we need a hearing, you said the latest date is in February, because of the extent of the application. It goes void after 150 days. Is that my understanding?
No, it doesn't go void after 150 days. It goes void after roughly 365 days from the date the application was filed. You've extended the clock a couple of times already, so it's my understanding that the clock expires sometime in February.
Yeah.
And that would give you if I didn't get a decision out by then, you'd have the right to go to court to seek a mandamus.
Understood. Okay.
So the 365 days means that application is dead, as I read state law. So basically, I have to get a decision out before that, within a year after the application was filed. I'm not sure that that's exactly the right number, but it's roughly a year.
Even if we toll it
Right,
for
you can't toll it beyond the year.
Understood. Okay.
Yeah, so they've told for 80 days, and so the max that you can toll is 215 days. So
That's the number I needed.
Yep. And so there's 135 days left that you can use to extend that clock beyond the February 24th.
Max. Okay. What was that last number? They've told 80 is 215, and how many is left?
They told for 80. The max you can do is 215. So they have 135 days left to extend the clock.
Okay. From today.
Is that correct, Maya? Yes. Yes.
Okay. Yes.
Okay.
Yeah.
Okay.
Yeah. So basically the February 24th. Is it February 24th?
Yeah, that's the
can
current
be extended
150 plus 80
Yeah.
is February 24th.
Yeah. So that can be extended out another 135 days.
Mhm.
I don't know. 30. From today or from February 24th? Sorry.
If they, but by tolling today, that February 24th date gets moved, however many days it's tolled.
Okay.
Yeah.
So is there any implication of the fact that this application was held incomplete past what the
No,
ordinance?
because the clock starts on after it's deemed complete, the 150-day clock.
Right, I'm talking about it was deemed complete past the date that it was supposed to be. So can we make sure that lines up? Maya, we can link back on that, make sure we're not missing any data.
Yeah. So it was deemed complete on which day?
July 8th.
July 8th. It was deemed complete because that was when we obtained the fire report, the fire report was listed as a missing item in your incomplete letter.
Right, I think there's like a 30-day window or something, or 60 days. I have to check on the ordinance again, but if
And
it's
the
not,
initial incompleteness was issued within that 30 days. It was, I don't have the dates off at the top of my head. I believe the application was filed on March 4th and I sent an incompleteness on March 28th. That was not responded to until mid-May. And then all the incomplete information was received as of July 8th. So that is the date of completeness.
okay, I'll review it again because I'm pretty sure the county held it past the deadline of what they're supposed to do. I think there's a deadline. I'm going to double check on it to be sure, but I'll work back with you, Maya, just to make sure we're not missing any deadlines on there.
And that may have given you a cause of action at that point, but I don't think it affects my decision deadline in any way.
Nope, just want to make sure we're
Yeah.
meeting all the deadlines, of course.
Okay.
Yep, state law gives us 30 days to review it for completeness. If we miss it, then it's automatically complete on the 31st day.
Okay.
Is that based off of when we submit our response back to you as well? If you don't issue a
The 30 days is from the date you submit your application. Yep. And then once
Initial-
we deem it incomplete, you have 180 days to make it complete.
right, I'm saying when we respond to an incomplete notice, right, and you guys respond back,
Mhm.
I can work it out with Maya. We can figure out.
Yeah, I think that's the best. We don't need to do that during the hearing.
Yeah. Just-
Okay, so I'm going to hold it open for a week initially for the county to submit new evidence.
And
And the applicant.
Yeah.
And testimony and the applicant as well, anybody. So that would be January 15th. And for the applicant to determine if they want more time beyond that first week. Assuming they don't want more time, I would hold it open for an additional week till the 22nd of January for anybody to respond to whatever was submitted during that first week. So second week is limited to responses only. No new issues can be raised that weren't raised during that first week. The 29th, until January 29th for the applicant alone to submit a final written argument without any new evidence. If the applicant submits a request to extend the open record and agrees to toll the 150-day clock for additional time, less than up to 215 days, I have to have at least 2 weeks to get the decision out at the end. So 215 minus, you guys can do the numbers, but if 135 days left, deduct 2 weeks from that, that's the maximum I would hold the record open or continue the hearing. If we want to continue the hearing, you'd have to make that request. We'd have to find out where we can fit it into the county schedule. If we just do an open record, you submit it in writing, that is easier to schedule. Regardless, I need something in writing by the 15th of January saying we want more time to submit additional testimony and evidence. We're tolling the 150-day clock for that purpose. And I would also need another week at least for the public and the county to respond to your new evidence. And for your final argument, which doesn't count against the clock, so it doesn't matter. So those are the numbers I'm working with. Let me know what you want. I will respond with an order if you request more time. If you don't request more time, the record will close on the 29th of January. Anything anybody wants to submit has to be physically received by the county by 4 o'clock. Okay, on the relevant date. The 15th of January for initial submittals, 22nd of January for responses, 29th of January for final argument. Anything you want to submit, you can submit to Ms. Ganser, and the county will forward it all on to me when the record closes. And Ms. Ganser, if the applicant requests more time, please send me an email letting me know so I can respond to that at that point.
Yes, I will.
Because otherwise I put these away until the record closes and I don't want to miss anything. Okay, so that concludes our hearing. Thank you all. Have a good afternoon.
Thank you.